morning. It is 10 a.m. on Tuesday morning, July the 9th, 2013. I call to order the Board of Funeral Directors and Embalmers, Department of Commerce and Insurance Division. To call the roll, please.
Wayne Hinkle.
Here.
Tony Highsmith.
Here.
David Neal.
Here.
Debbie T. Patterson. Jane Gray Sowell. Robert Starkey.
Here.
Anita Taylor. Mr. President, you have a quorum present.
Thank you, Mr. Griffin. I ask the board members to review the agenda for today's meeting, and the chair will entertain a motion.
Make a motion we accept as written.
Motion made by, I'm sorry.
Second. Oh, yeah, we got
Motion made by Mr. Neal, seconded by Mr. Starkey to approve the agenda for today's meeting. All in favor say aye.
Aye.
Any opposed? Thank you. I call your attention to the minutes of the April 9, 2013 meeting and ask you to please review those.
motion to approve.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Neal to approve the minutes from the August 9, 2013 meeting. All in favor say aye.
Aye.
Any opposed? Motion carries. I would ask you now to give your attention to the minutes of the meeting of May the 14th, 2013.
Motion to approve.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Starkey to approve the minutes of May 14th, 2013. All in favor say aye.
Aye.
Any opposed? Motion carries. Will you please let the minutes reflect that Ms. Taylor is in attendance today, please?
Yes, sir. Thank you.
Good morning, Ms. Taylor. I will now recognize Assistant General Counsel Benton McDonough. Good morning.
Morning. Thank you, Mr. President. First complaint is case number 2013008411. Case number 2 is 2013008412. Case number 3 is 2013008413, and number 4 is case 2013008414. On April 4th, 2013, a field representative conducted a routine inspection of the establishment operated by respondent number 2. During the inspection, it was determined that the funeral director's license of respondent number 1 expired on January 31st, 2013, and was not renewed until February 25th of 2013. Respondent number 1 serves as the manager of respondent number 2, and she signed in the capacity of funeral director on one death certificate while in possession of the expired license. Furthermore, respondent number 1 was the manager for respondent number 3 while in possession of an invalid license. However, respondent number 1 did not sign any death certificates in the capacity of funeral director for this respondent. And respondent number 1 signed one death certificate in the capacity of a licensed funeral director while in possession of an invalid funeral director's license for respondent number 4. In response, there was one response provided on behalf of all 4 respondents. One individual is responsible for renewing the professional licenses of the funeral directors and embalmers related to this complaint. The individual stated that she received the renewal notice and then placed the document in the improper file. The notice was located on February 8th, 2013, and the individual immediately sent in a check. However, the individual states that they were not aware that the license would not be reinstated until all fees and penalties were received by the funeral board. This individual was not aware of this until they received the notice of this through a letter from the board dated February 20th, 2013. And as of February 25th, 2013, the funeral director's license of respondent number 1 is considered valid. As far as the complaint history, we found no prior complaints for respondent number 1. For respondent number 2, we found a history of 1 dismissed complaint, 2 closed complaints, and 1 open complaint. For respondent number 3, we found a history of 1 closed complaint. And for respondent number 4, we found a history of 1 closed complaint. Based on that, we are asking for respondent number 1 for a consent order with a $250 civil penalty and authorization for a hearing. For respondent number 2, a consent order with a $250 civil penalty and authorization for a hearing. A letter of warning for respondent number 3, and a consent order with a $250 civil penalty and authorization for a hearing for respondent number 4.
Make a motion, we accept council's recommendation.
Second.
Motion has been made by Mr. Neal, seconded by Mr. Starkey to accept council's recommendations. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
I've got him messed up somehow. Let you clear it.
Number 5 is case 2013006811. Number 6 is case 2013006812. And number 7 is case 2013006813. On October 26, 2012, a field representative conducted a routine inspection of respondent number 5's establishment. The establishment license of respondent number 5 expired on June 30th, 2012, and was not renewed until July 20th of 2012. While in possession of an invalid license, respondent number 5 conducted 7 funeral or cremation services. Also, the funeral director's license of respondent number 6 expired on June 30th, 2012, and was not renewed until July 20th, 2012. Furthermore, this person made arrangements and/or conducted funeral services for approximately 7 individuals during this time. Respondent number 6 served as manager of respondent number 5 during this period of time, and the embalmer's license of respondent number 7 expired on June 30th, 2012, and was not renewed until July 20th, 2012. This person likewise provided embalming services for 2 individuals while in possession of an invalid embalmer's license. In response, 1 response was provided on behalf of all 3 respondents in this case. The respondent states that they did not recall ever receiving a renewal notice in the mail. However, they also stated that this does not mean that it was not sent to the respondents. Furthermore, respondent states that this is no excuse for failing to renew their licenses, and they are embarrassed and apologize for this oversight. We found a history for respondent number 5 of 1 closed complaint, and we found no prior complaints against either respondents number 6 or number 7. In this case, we're recommending for respondent number 5 a consent order with a $700 civil penalty and authorization for a hearing. For number 6, we're recommending a consent order with a $250 civil penalty and authorization for a hearing. And for number 7, we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Motion has been made by Mrs. Taylor, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 8 is case 2013006861. Number 9 is case 2013006862. And number 10 is case 2013006863. On March 21st, 2013, a local news station aired a story that the ashes of Danetta Hodges, who died on November 22nd, 2009, had allegedly been sitting on her family's mantle for 3 years until her family found out that they had actually obtained the wrong cremated remains. Hodges' granddaughter opened the temporary urn for the first time and found an identification tag with someone else's information inside. That information was pertained to James Gerald, who died in October of 2009 and whose cremation was handled by respondent number 8. The records of respondent number 9 show respondent number 8 delivered Ms. Hodges' body on January 4th, 2010, the same day that James Gerald's ashes were collected by Ms. Hodges' family. However, James Gerald's family states that respondent number 8 had them pick up his remains in December of 2009. The urn in possession of James Gerald's family contained neither a permanent identification device nor a disc. In response, respondents state that Mr. Gerald was cremated on November 10th, 2009 at 11 a.m. with an identification disc number 4895, and he was picked up on January 4th, 2010 by an employee of respondent number 8. Ms. Hodges was received by respondent number 9 on January 4th, 2010 at 9:27 a.m. and cremated on January 4th, 2010 at 9:30 a.m. with ID disc 4987 and picked up on January 18th, 2010 at 10 a.m. by respondent number 10. A receipt shows that Mr. Gerald's remains were picked up on January 4th, 2010 at 9:30 a.m. and Ms. Hodges' remains were picked up on January 18th, 2010 at 10 a.m. As far as prior complaints, we found respondent number 8 had 2 open complaints, respondent number 9 had 2 closed complaints, and respondent number 10 had no prior complaints. In this case, we're recommending for respondent number 8 a consent order with a $2,000 civil penalty and authorization for a hearing. Respondent number 9, we're recommending that we close this complaint. And respondent number 10, we're recommending a consent order with a $2,000 civil penalty and authorization for a hearing.
Eight has 2 open ones, according to this.
That's correct.
Situation, or something similar to, I guess.
Well, actually, there were several complaints filed in this situation, and they're also included in this, so that I believe those are pertaining to...
Motion to accept council's recommendation.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Are there any opposed? Motion carries.
Number 11 is case 2013006881. The complainant's mother, Danetta Hodges, passed away on November 22nd, 2009, and hired the services of the respondent to provide funeral services and cremation services as well. On March 23rd, 2013, the complainant's daughter opened the box containing the remains and found that the box contained the remains of James Gerald, who passed away on October 10th, 2009. The complainant met with the respondent, who apologized for the mistake but stated it was an error on the part of the crematory. The complainant then met with the crematory operator, who gave her a tour of the facility and explained the process. While discussing matters regarding James Gerald's container, the complainant and crematory operator searched for the disc that the operator would have tied around the inner bag to identify the remains in the container. However, no disc was ever located. The complainant received documentation showing that Danetta Hodges was brought to the crematory on January 4th, 2010, and cremated that same day. Ms. Hodges' remains were not retrieved until January 18th of 2010. Mr. Gerald's body was brought to the crematory and cremated on November 10th, 2009, and his remains were not retrieved until January 4th of 2010. The complainant then contacted Mr. Hodges' family, who informed her that they received Mr. Hodges' remains in December of 2009. In response, respondent states that they provided the names, dates of birth, dates of death, social security numbers of the decedents to the crematory. Respondent accepts responsibility for the misidentification of the remains. And after notification of the error in March of 2013, the cremated ashes of Ms. Hodges with the correct identification disc and name band were later found. Her family members have been notified that the ashes are ready for release. The Hodges family has been notified to return the ashes of Mr. Gerald and retrieve the ashes of Ms. Hodges. The respondent is sorry for the error and extends apologies to the Hodges and Gerald families. In order to prevent this from happening in the future, the respondent has taken steps to address the procedure used when transferring remains to and from the crematory. When accepting remains from a crematory, the boxes will be opened to verify the accuracy of the name, Social Security number, date of death, date of birth, and the cremation disc number. When returning the cremated remains to the family, the box will be opened to verify the accuracy of the name, Social Security number, date of birth, date of death, and cremation number. The family will then be required to sign a release form indicating the acceptance of the cremated human remains, date, and the time. We found a history of 2 open complaints in this case, and we're recommending that this one be closed as it was addressed in the prior complaint.
Accept council's recommendation.
Second.
Motion made by Mrs. Taylor to accept council's recommendation, seconded by Mr. Starkey. Any further discussion? All in favor? Say aye. Aye. Any opposed? Motion carries.
Number 12 is case 2013007951. The complainant's brother, James Gerald, passed away on October 11th, 2009. The complainant met with the respondent to discuss final arrangements, and they determined that a funeral would be held on October 17th, 2009, and that the decedent would then be cremated on October 19th, 2012, and the complainant would await final notification that the remains were ready to be retrieved. The complainant called the respondent on several occasions to learn of the status of the remains, but they were told that the crematory was running behind schedule. The complainant was notified on the last week of November 2009 that the remains would be ready for retrieval. On Wednesday, March 20th, 2013, the complainant was notified that the remains delivered in 2009 were not those of their brother, and they learned that the remains were not taken to the crematory until November 10th, 2009, and picked up on January 4th of 2010. The respondent states that it appears the decedent's remains were given to the wrong family, and in order to prevent this from happening in the future, the respondent has taken steps to address the procedure used when transferring remains to and from the crematory. When accepting remains from the crematory, the boxes will be opened to verify the accuracy of the name, Social Security number, date of birth, date of death, and cremation disc number. And when returning the cremated remains to the family, the box will be opened to verify the accuracy of the name, Social Security number, date of death, date of birth, and cremation number. The family will then be required to sign a release form indicating that they have accepted the cremated human remains, as well as the date and time that they were retrieved. Again, we found a history of 2 open complaints, and as before, we are recommending that this case be closed as it was addressed in a prior complaint.
Motion to approve.
Second.
Motion to approve by Mr. Hinkle, seconded by Mr. Neal. Under discussion, I do have one question, I guess just a clarification. All died on October the 11th, 2009. Paragraph, his remains were taken. Am I reading that correctly, board members, that he passed away on October the 11th, 2009, and in the last paragraph there on page 8, that on November the 10th, 2009? Is
That's correct.
okay?
Picked up on January the 4th, 2010.
That's correct.
Any explanation as to why his body apparently was retained at the first establishment for nearly 30 days before he was taken to the crematory?
The only explanation that we received during the complaint process would have been that there was a backup at the crematory, but that's the only answer I can give you at this time.
Any further discussion? A motion by Mr. Hinkle to accept council's recommendation, is that correct? and by Mr. Neal, seconded,
Yes.
and then discussion. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you.
Number 13 is case 2013-007191. The complainant provided a copy of the respondent's newspaper advertisement from March 26, 2013, in which the respondent offered a spring special of $750 for a 12-gauge steel vault. However, there was no record of such pricing on any price list. In response, respondent explains that an employee was told to change the price list and the effective date of the price list prior to running the advertisement in the newspaper. However, this individual failed to do so. Respondent manager sat down with the employee after the complaint was filed and corrected the matter. The respondent included a copy of the updated price list with their response. We found a history of 3 prior complaints, 1 dismissed and 2 closed. And we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Recommendation, we accept counsel's.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle, to accept council's recommendation. Any further discussion?
Yeah. What in the world is a...
We have a motion on the floor that has been seconded. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 14 is case 2013-007531. The respondent was found to have conducted committal and interment services of Desi Marie Cherry at Rob Draper Memorial Cemetery in Gainesboro, Tennessee on February 13, 2013. These actions constitute funeral directing in the state of Tennessee, and an individual with an active Tennessee funeral director's license in good standing with the board was required to conduct these services. However, no such person was present and in charge during these services. In response, the respondent states that they would like to apologize for their oversight of the law requiring that a licensed Tennessee funeral director be in responsible charge for the committal and interment services in this case. We found no history of prior complaints, and we're recommending a consent order with a $350 civil penalty and authorization for a hearing.
Recommend we accept council's recommendation.
Second.
Motion has been made by Mr. Neal, seconded by Mr. Starkey, to accept council's recommendation. All in favor say aye.
Aye.
Are there any opposed? Motion carries.
Number 15 is case 2013-007851. On March 6, 2013, a field representative conducted a routine inspection of the respondent establishment. It was determined that 1 cremation authorization form was not signed by a licensed funeral director. 2 files lacked a cremation authorization form in the file. On the general price list under direct cremation, the heavy cardboard container being sold to the consumer for $145 on the statement of funeral goods and services selected must be added to the general price list. Under the casket price list, under alternative container, the heavy cardboard container being sold to the consumer for $145 on the statement of funeral goods and services selected must be added to the casket price list. On the statement of funeral goods and services selected of the file selected, 8 consumers were sold an item that was not included on any price list provided to the consumer for review. Furthermore, on the statement of funeral goods and services selected of the file selected, 5 consumers had prices inconsistent with the prices given to the consumer on the casket price list and the general price list of the establishment regarding the Batesville Stratus alternative container. And on 1 statement of funeral goods and services selected, the merchandise and its description were not shown on the contract before the consumer signed the contract. In response, the respondent admits to the violations and oversight regarding the cremation authorization forms and has enclosed a copy of them in the response. As for the heavy cardboard container, the respondent apologizes for the oversight of not adding the merchandise to the general price list. Respondent admits that the heavy cardboard container was not on the casket price list under alternative containers, as they were offered at no charge in an attempt to assist families with very little funds, and the item is no longer offered. As for the issue relating to the Batesville Stratus, the respondent has taken steps to ensure that the container and the removable insert for the container will be itemized on statements in the future. Consumers were not overcharged as alleged by the field representative, and consumers were made aware of the charge for the container and the removable insert for the container prior to signing their respective statements. As for the contract lacking the appropriate description prior to the consumer signing the contract, the consumer was in possession of the general price list, which contains the item description and price, but the respondent is now aware that the merchandise and description was not in one of the particular statements. We found a history of 1 open complaint and 2 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a recommendation, we accept counsel.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 16 is case 2013-007881. On March 5th, 2013, a field representative conducted a routine inspection of the respondent establishment. 2 employees are using business cards with the title sales manager and independent sales representative. However, neither is a licensed funeral director, and the cards fail to clearly note that they are not licensed funeral directors. As for the general price list, the veterans plan being offered to the consumer by way of mail-out from the respondent is not listed on the general price list, and under the statement of funeral goods and services selected, 3 of the files reviewed failed to provide a description of the merchandise sold on the contract as required. Furthermore, a blank statement of funeral goods and services selected could not be provided for review, and the latest inspection report of the crematory used by this establishment was not available for inspection. In response, the respondent states that that is not a violation for the employees to wear badges or provide business cards with the title sales manager or independent sales representative while working for respondent. Respondent states that they are not licensed funeral directors, nor do they perform the tasks of a funeral director. However, they will change the titles on the business cards and badges to read pre-need sales agent, along with the appropriate registration number. As for the general price list, the respondent states that no violation of the funeral rule has occurred, as the plan offered to veterans does not involve any prices that differ from those indicated on the general price list. Rather, the plan offered by the respondent involves the offer of assistance with the application of veterans' benefits from the federal government. And also in the statement of funeral goods and services selected, respondent provided a response with the merchandise sold and its description as well. As for records, the respondent enclosed a copy of the blank statement of funeral goods and services selected for review, and respondent enclosed a copy of the inspection report for the crematory utilized by this establishment. We found a history of no prior complaints, and we're recommending a consent order with a $1,000 civil penalty and authorization for a hearing.
Motion, we accept council's recommendation.
Second.
Motion is made by Mr. Neal, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 17 is case 20...
Let the record reflect that Mr. David Neal recused himself from item number 17 on the legal report.
Number 17 is case 2013-008401. On April 1st, 2013, a field representative conducted a routine inspection of the respondent establishment. On the general price list, the price range for direct cremation listed on the general price list was incorrect when compared to the price of caskets listed for the sale on the casket price list. 5 containers listed for sale under the direct cremation heading were not included on the casket price list, and those were the Pacific Pine, the Bayview Beach, the Stratus, the Brown Standard, and the cardboard container. The price range for immediate burial on the general price list was incorrect when compared to the price of caskets offered for sale on the casket price list. Immediate burial price with the minimum casket from facility was incorrect when compared to the price of the minimum casket on the casket price list. Also under immediate burial with minimum casket from facility, the minimum casket listed on the general price list was the Herculite gray embossed doeskin oval top, which was not included on the casket price list, and the casket price range was incorrect on the general price list when compared to the listing of the caskets offered for sale on the casket price list. Furthermore, the adult outer burial container price range was incorrect when compared to the listing of the outer burial containers offered for sale on the outer burial container price list. And on the casket price list, the casket price list must include a listing of all alternative containers offered for sale for direct cremation. The casket price list had no alternative containers listed for sale as required by the FTC. Respondent states that the establishment was using the incorrect general price list and casket price list at the time that the field representative conducted the routine inspection at the establishment. We found a history of one closed complaint, and we are recommending a consent order with a $250 civil penalty and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation. Any further discussion? All in favor, say aye. Aye. Any opposed?
Number 8.
Motion carries.
Up there.
Sorry, council.
Number 18 is case 2013-009731. On May 8, 2013, a field representative conducted a routine inspection of the respondent establishment. The yellow pages contains an advertisement listing of the respondent establishment for affordable burial and cremations with the price of $695. However, the advertisement lacks an itemized price for each item, procedure, and service. Furthermore, upon examining the respondent's files, it was determined that several files did not contain a copy of the written cremation authorization forms as required. Furthermore, the manager admitted that he failed to place a copy of the cremation authorization forms in 4 of the cremation folders. Respondent states that it was their belief that a direct cremation with the container provided by the establishment is one of the single 16 goods and services required by the funeral rule to be presented on an itemized basis on the general price list. Respondent states that he ran the advertisement by Scott Gilligan, who told him that the advertisement looked appropriate. Respondent states that he was never informed to check state law regarding advertising, and respondent takes full responsibility and states that he was only acting in ignorance of the law. Furthermore, respondent has taken steps to remedy the violations regarding the cremation authorization forms and has placed those documents in the appropriate files. We have a history of no prior complaints, and we're recommending a letter of warning in this case.
Motion to accept council's recommendation.
Second.
Motion's been made by Mrs. Taylor, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion?
Why is there no fine in this case?
This was a matter that we have been working closely with this individual in this matter, and they have gone out of their way to work with us to remedy the situation and to address the issues that we felt were appropriate. And based on that and their willingness to take responsibility for the violations, we felt like a letter of warning was appropriate in this case.
When you put something in the yellow pages, you can't correct that overnight. It takes a year to correct, you know.
That's, yeah,
So-
yes.
Mr. Starkey,
Okay.
Mr. Starkey, the ad in the yellow pages, according to the funeral rule, is probably correct, but it's because of a state law that it's
Okay.
incorrect.
Okay.
He had done everything he thought he needed to do. He had contacted an attorney to get it reviewed, and then he had also, at some point, made contact with the Federal Trade Commission. And he really felt like that he was right, and he had the price for the direct cremation. It was just all the components he did not have.
Any other discussion? Motion made and duly seconded. Call for the vote. All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 19. Number 19 is case 2013-000452. On April 23, 2012, a field representative conducted a routine inspection of the respondent's establishment. It was determined that the respondent's funeral director's license expired on June 30th of 2010 and had not been renewed at the time of the inspection. The respondent signed as the funeral director on 3 statements of funeral goods and services selected during that time period. And the respondent also served as the manager for the establishment. Therefore, there was no licensed funeral director serving as manager for the establishment at the time of the inspection. In response, a new manager was put in place for the establishment on May 11th of 2012, and this manager states that she has no knowledge of anything that occurred prior to May 11th of 2012. Owner of the establishment states that the that he apologizes for his employee's funeral director's license lapsing, and states that changes have been made to prevent incidents like this from happening again in the future. Furthermore, the owner provided a copy of a check he states that he provided to the respondent in 2010 to allow her to renew her license. As for history, we found no prior complaints, and this case was originally presented as one of 3 on March 12th of 2013. The board at that time agreed with counsel and approved discipline in the form of a consent order with a $300 civil penalty and authorization for a hearing. Subsequent to the board meeting, counsel received notification from the respondent's family that the respondent is currently suffering from dementia and the progression of Alzheimer's disease. Furthermore, the respondent's funeral director's license expired on June 30th, 2010, and there has been no attempt to renew the license at this time. Based on that information, we're recommending that this particular case be dismissed.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendations. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 20 is case 2013-001271. This case was originally presented at the previous meeting in May of 2013. The owner of this establishment operates the business as a sole proprietor. The owner recently passed away, therefore we're recommending that this case be closed.
Accept council's recommendation.
Second.
Motion made by Mrs. Taylor, seconded by Mr. Hinkle to accept council's recommendation regarding item number 20. Is there any further discussion? All in favor say aye. Aye. Any opposed? Motion carries. Council, there are 2 public chapters that have been recently approved by the legislature, is my understanding. Chapter number 287 regarding cremation of cremation of unclaimed bodies. And chapter number 437, removal services registration. Would you like to discuss those items with us at this time?
Yes. As you can see, Chapter 287 allows the coroner, medical investigator, or medical examiner to direct a cremation of any unclaimed body. Furthermore, a public official, custodian, or active head of any public institution where an individual passes away must notify the nearest relative of that individual. And the law further states that if no claim is made for the body by the chief medical examiner or their representative within 72 hours of the death, that the body may be buried as provided by law. And a medical examiner may deliver the body to relatives or cause it to be buried or cremated at the expense paid from property that is located with the body, or from the county treasury or county mayor if no property is found with body at that time. That's an overview basically of Chapter 287, and that deals with the cremation of unclaimed bodies. And then the other one is Chapter 437, and that deals with the removal service registration, and it basically adds a definition in Title 62 of a definition of removal service, and then it states that the registration of a removal service will be good for 2 years starting January 1st of 2014. And it also lists some exceptions, that being a licensed funeral director, a licensed embalmer, a licensed funeral establishment or a person's employees, a federal, state, or county government agency, or private for-profit ambulance service license under Emergency Medical Services Act of 1983. Anything falling under that description would be exempt from the requirement to register as a removal service under Chapter 437.
Let's take these separately. First of all, Chapter number 287. Generally speaking, you have any questions or concerns about any of the wording in Chapter 287?
And that's a matter that we addressed during the legislative process. That was brought to our attention, and we worked with the sponsors and legislators of that bill to work on the wording of that particular bill.
Any questions or comment for any of the board members regarding chapter number 287, regarding with the cremation of unclaimed deceased human beings? Let's give our attention to chapter 437 regarding removal services. And same question, council, is there any questions or concerns you have about the wording in that particular chapter?
Similar to the first one, this bill was brought to our attention during the legislative process, and the department gave its opinion on the matter, and there were some concerns regarding the wording of the exemptions or exceptions to the definition of removal service, and that's something that we're still in the process of discussing prior to any rulemaking process that will come up in the future as the law does not go into effect until January 1st of 2014.
I have a comment and a question. I am somewhat disappointed in the broad exclusions or broad exemptions. I thought this would be a little more particular as to who it would govern, but I see under item B, number 1, that all licensed funeral directors, licensed embalmers, and funeral establishments are exempt. I can understand a funeral establishment being exempt from this because they would naturally abide under other rules and regulations. But I am somewhat concerned that just simply because a individual is a licensed funeral director or a licensed embalmer, that they could be engaged in removals and transportation of deceased human beings without any governing authority outside of that governing their actual funeral director and embalmer's license. So I guess personally speaking, it's a lot broader than I had anticipated it being, and expressed some disappointment in that. Any other comments regarding that from the board?
I think a licensed funeral establishment or person's employees would have been sufficient there. That would have covered for a funeral home, you know. But according to this, as a funeral director, I could start my own removal service without, has no affiliation with the funeral home, without coming under scrutiny.
Okay, that is the way I read it. Counsel, is that your similar interpretation?
That's actually one of the things that we're going to have to discuss further to see how this is implemented exactly, and to see how the law will be implemented against those individuals who are individually licensed funeral directors and licensed embalmers, and whether or not the exemption applies to them individually, or if they have to work for an establishment. That's something that concerned us in the wording, and as to whether or not that's the appropriate interpretation of the statute.
Would it be the general opinion of the board, and I'm asking you as board members, that do you feel the same way in general as Mr. Starkey and myself feel?
I do.
Yes.
Yes.
Council, if you would, please take note of that in your further discussions. The board is somewhat disappointed in as broad of the exclusion as that is, and I don't know if there's any turning back or any redoing. Apparently not. It's been, I think, signed and put into place, hasn't it, Mr. Gribble? It will go into effect. It's been signed by the Speaker of both and been signed by the Governor, so apparently it's set to go January 1st. Is that right?
January 1st of 2014 would be the implementation date.
Council, will you follow up on that for us, please, if there's any action to be taken?
Yes, sir.
Okay. Another question that I would have, also under Part B, item number 1, is interpretation of the term or person's employees. I understand what a licensed funeral director is. I understand what a licensed embalmer is. I understand what a licensed funeral establishment is. But the last part of that says, or persons employees. I'm somewhat confused about the word persons.
It should read funeral home employees, I would think, instead of persons, because that could be I could, as a licensed funeral director, have a livery and hire somebody else, but I'm not associated with a funeral home, and just kind of bypass the law.
Counsel, what is your feeling about the term persons there?
That was one of the areas that we would like more clarification on, because it is rather vague as to whether or not that pertains to an establishment's employees or if it pertains to a individual who's a licensed funeral director and embalmer, and if it pertains to their employees as well.
You said you're concerned about the interpretation of that. Who would actually render the interpretation for that terminology there?
We could request an Attorney General's opinion on that matter.
And we as a board request it, or how do we go about this process to get that determined? Or
I believe you all would be able to request that, and then if you request that, then we can set the wheels in motion to make that happen.
That request would be to, I guess, the Attorney General's office?
That's correct.
What's the will of the board concerning that particular item?
I think we need to
Make a motion.
take a motion and go
Okay.
there and, you know, make a motion that we do whatever it takes through your office and Mr. Gribble there to have the Attorney General's opinion, I guess, rendered on this particular thing and maybe the other one too.
I think a simple fix, of course, through the Attorney General, if you make a recommendation, does not include a licensed funeral establishment or the establishment's employees. Take out the funeral director and embalmer. In other words, you know, we as funeral establishments should be able to pick up bodies and haul them, you know.
That's the way I understand it. The law is already in place, so there's no changing of the law. All we would get is an interpretation of the Attorney General's opinion, and in order to change the wording in that, there would have to be an amendment made to this law in the future legislative process, would there not?
That's correct.
So all we would be asking for is Attorney General's opinion as to what the word persons, employees renders.
President,
Yes, sir.
I think it would be helpful to know ahead of the game whether or not these people, these funeral directors and embalmers who have removal services, whether or not they're required to register, because if we don't obtain an opinion from the Attorney General's office to know for sure what their thinking is, then we may do it one way and find out a year and a half or 2 years into it we've done it the wrong way. And it would be helpful to know in the beginning, because we only want the people that are required to register as the law requires it, and those that aren't to be exempt. But I would feel more comfortable as a director of the program if the board did seek the Attorney General's opinion and we knew ahead of time just exactly which companies had to register and which ones were exempt.
It appears as broad as the exclusion is here, there would actually be very few, probably in our state, that would even have to register.
When we did the physical analysis on the bill, if my memory is correct, and I didn't look this up this morning, I think we expected about 40 companies to register the first year. Of course, we were taking into consideration that it would only exempt establishments and their employees, and funeral directors and embalmers, but not funeral directors and embalmers who had employees. We based that on that analysis. So if in fact the funeral directors and embalmers who have employees do not have to register, then that number will drastically go down from 40 to, I don't know, much smaller number anyway.
We have a motion on the floor to ask General Counsel to get an Attorney General's opinion under removal services, item B, section 1 in particular. Is there a second to that motion?
Second.
Motion was made by Mr. Hinkle, seconded by Mr. Starkey. Now, we clear on what we're asking for, Board? Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Counsel, generally, how long does that take to get that opinion?
It's hard to put a particular time frame on that. Mr. Gribble and I were speaking on the matter previously, and with the fact that the legislature is not currently in session, that may help to speed things up a little bit, as there won't be as many requests for opinions made to the Attorney General's office. But at this time, I would hate to put any sort of time frame on it for you for that.
Reason for asking, with the law set to go into effect January 1, I understand that it is now our duty as a board to establish a means of registration, forms to do it on, penalties for violations, and things of that nature. Is that the next step, Mr. Gribble?
That would be, I
Counsel.
guess, be better directed to Mr. McDonough.
Yes, I believe that would be the next step, and I believe that's something that we can move forward on without necessarily having the Attorney General's opinion on that. As I understand, the Attorney General's opinion would only explain to us the interpretation of who would be exempt from actually following through on the registration process.
Our next step would be a work session, would it not?
That's correct.
And then after that work session, what would be the next step? Would it take a rulemaking next step, or?
Right, it would be rulemaking and the rulemaking process at that point.
That naturally will take some time for those to take place. Does the board feel comfortable with moving forward with a work session in our August meeting? Would that be a good timetable? Then that would give us time for rulemaking later, and all to be done before January 1?
I believe that would be appropriate.
Does a work session have to be advertised in our agenda?
Yes, sir, it does. We would properly notice that, just like we do the agenda. Do you want to do it in the afternoon, like we've done the work sessions in the past, or is that the preference of the board to meet it back at 1 o'clock for the work session, or what's your will and pleasure?
I've got a sore throat. It's getting worse. I think that doing it after lunch, because anybody that's got any business between the coming in front of the board, they don't have to sit through the work session and stuff, and that way their items have been handled, and then we can go take a break, go to lunch, and come back, and then, because work sessions can last, no telling how long. That's just my opinion.
Board in agreement?
Yes.
Let's, Mr. Gribble, if you will, schedule us a work session at approximately 1 o'clock on the day of our August meeting, if you would, please.
Yes, sir, I will.
Thank you.
I think originally the intent of the law is not to punish funeral directors, but this is just somebody that's not licensed, out of the blue, decides to go into the removal service, so it needs some regulation. So I think that's where the original intent came from. There you go.
This keeps me from opening up a spring special with my Cadillac.
Counsel, do you have any other items to come before the board under your legal report?
Not at this time.
Okay. We'll move to administrative matters, and Chair will recognize Executive Director Robert Gribble for that report.
Thank you, Mr. President. First, we have the licensee report, which is a report of licenses administratively approved by the Executive Director pursuant to the Board authority for the period of May 14, 2013 through July 8, 2013. We have 3 new establishments: McWright Funeral Home in Dyersburg, Revelation Funeral Home LLC in Nashville, and Tennessee Valley Crematory LLC in Mont Eagle. Also, as far as individuals, there were 4 individuals who received both a funeral director and embalmer's license, 3 individuals who received a funeral director only license, and 1 individual who received an embalmer only license. The embalmer was licensed as a funeral director previously and had met all the qualifications to receive his embalmer's license at that time, but decided to wait a few weeks or a few months in order to do that. So that's why he's getting an embalmer's license only at this time. Closed establishment report for this board meeting. There's 1 establishment that's reported closing since the last board meeting. That's Northeast Tennessee Mortuary Services, which was at a physical location of 4893 Highway 11E, number 2 in Bluff City, Tennessee. As far as the disciplinary action report for this meeting, this is a report of the consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of May 1, 2013 through June the 30th, 2013. Several listed there. If you have any questions, I'll be glad to. Establishments, their violation, and the civil penalties listed, which those are in the disciplinary action report. As far as the complaint report, as of yesterday, we had a total of 116 complaints open. 6 of those were against funeral directors and or embalmers, and 110 of them were against funeral establishments. That concludes my report.
Thank you, Mr. Gribble. The chair will entertain a motion to accept the administrative report as presented by Mr. Gribble.
To accept.
Second.
Motion been made by Mrs. Taylor, seconded by Mr. Neal. All in favor say aye.
Aye.
Motion carries. Next order of business on our agenda is approval of license applications. We'll again turn the meeting back over to Executive Director Robert Gribble for explanation of what's taking place here.
The person is Mr. Charles Arthur Fowler of Memphis, Tennessee. If you would, either come to the podium or either one of the first chairs there to the aisle, either one. Mr. Fowler's application is for a funeral director and embalmer, and based on the applications, the board may, among other pertinent statutes and rules, specifically examine Tennessee Code Annotated 62-5-317 in making a determination whether the applicant meets the requirements for licensure.
Members now have the opportunity to review Mr. Fowler's application.
The DUI. So I did provide a personal statement, but I'll try to make it as brief as possible. I did receive a DUI in February of 2010. I was driving a colleague home that evening from an event, and I personally thought that I would.
Fowler, the red light needs to be on as you're speaking into the mic. You might need to move a little closer or possibly speak a little louder. Thank you.
Sorry about that.
That's for recording purposes.
Yes, sir. As I was saying, I did provide a colleague a ride home that evening. I made an error. I was actually a distracted driver. I was typing the address into a GPS trying to find home, and my vehicle crossed the line twice in front of a police officer, and he pulled me over for, to ask me what was going on. And at that moment, he asked me if I was drinking. I told him I did have some drinks that evening. The associate that was with me in the car was obviously drunk, and that's the reason why I was taking him home. So the police officer made an assumption that we were both basically at the same level of intoxication. He asked me to get out of the vehicle, asked me to do a couple of tests and questions, and at that point, he asked me to do a breathalyzer test, in which I volunteered to do because I thought I was fine, and I was really at the point of .088, and when all was .08, so I was above the all. So as you can see, I put all the information together. I've met all the requirements. I was able to get my driver's license back, and that's been 3 years.
For insurance, didn't it?
This whole experience has been very expensive.
We'll say that Mr. Fowler has provided the office and for the board members the most thorough response that we've ever received. I think anytime we've asked for additional information, he's been very cooperative and provided very detailed responses and documentation to substantiate his narrative.
Like the traffic school certificate that you went to.
Just my luck. Yeah, that was the name of the school.
Make a motion, we grant.
Second.
Motion has been made by Mr. Starkey, seconded by Mr. Hinkle, to grant Mr. Fowler's licensing. Any further discussion? All in favor, say aye. Aye. Any opposed? Motion carries. Congratulations, Mr. Fowler. And I guess Mr. Gribble can tell you what you need to do at this point.
Mr. Genesis will get with him and give him the information.
Thank you, Mr. Fowler, for appearing today.
The next applicant is Stephen Oliver Gray from Lakeland, Tennessee, who is a funeral director and embalmer of Reciprocity, and specifically looking at today is 62-5-311B3. Mr. Gray does not hold a associate's degree, but he does have a diploma. He has passed the national board, both arts and sciences. He was licensed in 1994 in Arkansas. His license remained current and in good standing for 5 or more years, and he has furnished his documentation for his places of employment for the previous 5 years. Now, not on your iPad because we only got it late yesterday afternoon. It was in yesterday afternoon's mail. But to supplement his application from Griffin, Leggett, Healy, and Roth Funeral Home in Little Rock, Arkansas, there's an affidavit by the Director of Operations to say that Mr. Gray worked for their funeral home as an embalmer and funeral director from February the 2nd, 2008 through September the 12th, 2008. So that's the little part that was needed to put him over the 5 years, and that just
Make a motion, we accept.
well, that's
Thank
not
you,
the
Mr.
one that
Gribble.
came yesterday.
Yeah.
There's another one that came yesterday, but in totality, the one that came yesterday was from Beasley Wood Funeral Homes or Geiger Quillen Funeral Homes. I may not be pronouncing those names right, but that one went back to from October of 2004 to February of 2008. So that altogether, all the information is there.
All the information you have, he meets the requirements.
Provided the board agrees it does. Yes.
Your most recent employer was the Griffin, Leggett, Healy.
My most recent employer was Roller Ballard Funeral Home in Benton, Arkansas. Before then was Griffin, Leggett, Haley, and Roth in Little Rock.
Basically speaking, except maybe for just short transitions between each location, you've been licensed pretty much continually since 1994.
I have been licensed continuously since 1994, yes.
Any other questions for Mr. Gray? We have a motion on the floor by Mr. Starkey, seconded by Mrs. Taylor, to grant licensing to Stephen Oliver Gray. Any further discussion? All in favor, say aye. Aye. Any opposed? Thank you, Mr. Gray, and congratulations.
Thank you.
I have one establishment application. It's the establishment application of Jackson Funeral Services at 106 Administration Drive in Oak Ridge, Tennessee. It's a new establishment. The ownership is a partnership owned by Rhonda Jackson Oliver and Larry David Oliver of Oliver Springs. These folks own another funeral home already in Oliver Springs, and Miss Rhonda is the manager at that location, and Mr. Larry is going to be the manager. He's the proposed manager for the new location.
All the requirements been met, Mr. Gribble? Everything in order?
Everything's in order as far as her concern is. It's just
Noticed
the
that,
determination of the board.
Under receipt of human remains to this location is not applicable, and receipt of cremated remains is not applicable, and preparation facilities are not applicable for this location. Can you explain that to us, please?
Yes, all of the embalming and so forth will be done at our Oliver Springs location. This, the Oak Ridge office is basically just a business office.
They'd have a selection room there, or a visitation room, or chapel of anything of that nature?
We'll not have a visitation or chapel, we will have selection, yes.
On all your cremations, they'll go to Crossville Memorial.
That's correct, yes.
There'll actually be no services or visitation at this location?
No, sir, will not.
Nobody's present at any time?
No, no, sir.
At your 7th or 8th page from the front of that, there's an email there from Mr. Bill Luna, who is the field representative to me, that we included.
Does meet the zoning requirements and everything. Motion to approve.
Second. Motion to approve, council, to approve licensing of Jackson Funeral Services in Oak Ridge, Tennessee, has been made by Mr. Hinkle, been seconded, I think, both by Mrs. Taylor and Mr. Starkey. Is there any further discussion? Ask Genesis for a roll call vote, please.
Bonnie Highsmith,
No.
Wayne Hinkle,
Yes.
Robert Starkey,
Yes.
Anita Taylor,
Yes.
David Neal.
Yes.
Motion carries. Congratulations. All will see Ms. Genesis at the conclusion of the meeting, and she will, I think, have some information.
Actually, theirs is already, because that's an application fee, licensing fee, so it's already paid. We just need to send you a license number. We'll try to do that. We have another matter going this afternoon, so we'll try to do it either late this afternoon or tomorrow. But we'll contact you by phone and let you know.
Bill, do you have any other items to come before the board?
I do not, sir.
Council, do you have any other items?
Yes, sir.
Board members, do you have any other items?
No.
We will meet again in our August meeting and plan for a work session after lunch. Would that be 1 or 1:30 would be your recommendation?
Kindly to see how long the agenda is that day. Mr. Highsmith?
Yes, sir.
They're not on the agenda, but I see a member in the audience that's asking to be recognized. That's your call. We can't take any, I don't think you can do any business, but you can certainly listen if that's your will and desire.
Would have any objection?
No.
You approach the mic, please, and state your name and the nature of your business. Please be advised, as Mr. Gribble said, there would not, since this is not an advertised item that is on our agenda, there would not any action be able to be taken today, but you're welcome to state your case or your concerns before the board. Mr. Ganaway, I'd ask you to please speak directly into the mic and make sure that red light's on while you're speaking, please.
Steve Ganaway with Henry Smith Funeral Home here on the name change today. Henry Lewis Smith Funeral Home, I'm sorry, sir.
Regarding a name change?
Yes, sir.
And Mr. Highsmith, he and I have had some conversations, and I may have some fault here for him not being on the agenda. We had some conversations about what that name change was going to be, and he does have a desire to change the name, and it's a name that I can't administratively approve. So I know it's not normal and usual. I would ask that you consider his request today unless legal thinks we're out of line.
Yes, sir.
Under a normal name change that we'd go through.
No, sir, it's not normal. If it was normal, I could approve it.
Okay.
Anyway, would you state the name of the current establishment, please?
Henry Lewis Smith Funeral Directors.
And Mr. Gribble, that is a operating entity currently, an establishment?
Yes, it is a licensed establishment. It's located on Buchanan Street here in Nashville. And Mr. Smith is no longer at that business, and Mr. Ganaway would like to change the name of it, and Mr. Smith would like for the name to be changed, according to his expressions to me. Both of them have expressed that to me, that they want the name changed, and that's certainly not a problem. The problem is as to what the name is going to be changed to.
Mr. Ganaway, would you state the new name for that, please, that you are requesting?
SAG Funeral Home.
Spell that, please.
SAG.
SAG Funeral Home.
Now, that is not how the application is submitted. The application was submitted S.A.G. which I think it's important to the board to know what that represents.
Anyway, would you state to us what the S, the A, and the G represent?
SAG is SAG's Entertainment and Promotion. That's been my company's name for the last 20 years. I just want to change that over and piggyback off of my company's name. I do have a company by the name of SAG Entertainment for the last 20 years.
It would be SAG Funeral Home,
Yes, sir.
S.SAG.
SAG. Yes, sir.
But there's no period.
No periods after the S and A and G.
Just SAG, just plain, just SAG, SAG.
Or no periods?
No, sir.
Okay. Then we would need an amended application to reflect that, so that you're not, because the last application that I saw that was submitted had a S period, A period, and G period.
Might have done it wrong, sir, and I apologize.
So that's no problem. We can just get an amended application. There's no additional fees or anything like that. It's very important that the board approve your application as you intend to operate, because there's a violation if someone operates a name different than how it's approved. I'll speak to the counselor just a second, please.
Yes, sir.
SAG Funeral Home, is that the way you want it, Mr. Ganaway? Legal counsel and I have spoken, and of course it's the board's decision to make, because I couldn't administer, and let me tell you why I couldn't administratively approve that. When we got the application, it was S period, A period, G period. It's my understanding that represents Mr. Ganaway's son's name. But when you take those periods outside that, and since he has another company that's already operating just as SAG, then I personally don't have a problem with it, and legal counsel can speak for himself. I think he's indicated to me he doesn't have a problem with it. But that was why I couldn't approve it, is because I didn't feel like that I could approve something that might be in violation of 62-5-314. And I do apologize to Mr. Ganaway, because you were not officially on the agenda to begin with. That's my fault, and I accept responsibility for that and apologize for it.
Proper time, no way. We had a service this morning with Mr. Smith.
It would be up to the board to determine whether or not this meets the requirement under 62-5-314 for the use of names of unregistered persons being restricted.
It's not a person, is it? It's SAG, it's just a...
They have one out on South Nashville. That they have several SAGs out there, entertainment and studios and whatnot, on Music Road.
Stated you have another business that's operated under the name of SAG. Okay. And is this corporation? Is it a corporation? And is it a corporation that's going to own this establishment, or is it?
No.
Okay, this is going to be a sole proprietor.
Yeah.
Okay.
Cite that rule, Mr. Benton, that you just mentioned in your last statement.
62-5-314, it states that the name of any living person, and this is on page 88 for the rest of you, the name of any living person who has not been licensed as provided in this chapter shall not be shown or displayed upon any funeral establishment or used alone in, as part of, or in connection, association, combination, or together with the name or title of any person, firm, corporation, or other form of enterprise engaged in undertaking or embalming on any card, sign, stationery, or other printed or written instrument or device, in any announcement or advertisement, or in any manner so as to give or tend to give the impression that the person is licensed or entitled to practice either as a funeral director or embalmer.
And the way I have a question then, because, and this is from memory, but my memory is that the establishment is owned by an LLC at the present time. Okay. And that LLC is still going to own it. You mentioned they're a sole proprietor, but it's my understanding that the LLC is still going to own the funeral home, and the LLC is not going to change names or anything, correct? I'm confused.
I'm kind of confused from where you...
Okay. There are two locations of Henry Smith Funeral Homes. One is on Buchanan Street here in Nashville, and one is in Clarksville, Tennessee. The one that you're asking for a name change is the one that's located at Buchanan, I believe, 1503.
So we want to get to Clarksville at a later date. I just tried to move one thing at one time.
I understand. So the funeral home at Buchanan Street is presently owned by Henry Smith Funeral Directors, LLC?
Yes, sir.
Okay. Is that LLC going to remain as the owner of that establishment, no matter what the name of it is? If the answer to that is yes, then all you need is a name change. Now, if the name of the LLC or a different LLC or a different corporation or a sole proprietor or partnership is going to own the business located at 1503 Buchanan Street, then it's necessary to do a change of ownership. But if all you want, well, when I say change of ownership, that means the entity. It doesn't mean that the people are going to change, and the people can change. The people can change as long as it's owned by a limited liability company or a corporation, but if it's owned by a sole proprietor or a partnership, then when the people changes, that changes the ownership of it. You're not picking up.
If you put it that way, sir, the ownership will change. As a matter of fact, the ownership has already changed. You know, that paperwork has already been done.
Will the LLC be dissolved, or will it still be in place?
I have to get with my attorney about those things because I don't, I don't know. I have to get with him about that, and he have to explain all that to me. I'm not familiar with that.
Because as Mr. Gribble was stating, that if the LLC is still in place and you're just changing the name of the funeral establishment, then you'll just have to do a name change, and
that's all we're doing right now. Yeah.
Okay. Mm-hmm. But I think we need more clarification once, from your attorney to determine whether or not the LLC will still be in, overseeing and be empowered and be the owner of of that property.
Yeah. Mm-hmm. Confused.
You said that the LLC, the ownership is done changed. Is that what you're saying?
Well, Mr. Smith turned over his percentage in the establishment. So when he done that, they had to go back and redo the LLC.
You spoke about an attorney that advises you.
He's handling the LLC and all of that,
I think we need more information before we can do anything, because I'm sitting out here, I don't understand. One minute we're talking about a name change, then we're talking about possible ownership change, then you're talking about a LLC, and I'm not an attorney,
Yeah, we're not changing any ownership. We're not changing any ownership. The ownership will remain the same, exception of Mr. Smith.
Well, if I made
You're buying the LLC. Mr. Smith's getting out of the LLC, but the LLC will remain.
Yes, sir.
Okay.
Yes, sir.
The LLC is considered an individual, right, and so they can have ownership of the establishment, and therefore, if the LLC is still in control and still owns the company, there's no change in ownership technically, because the LLC is the one that owns that property. And so I think what we're trying to determine is whether or not the LLC is going to be dissolved, or if it's still going to be in place and still have the ownership. Because if that's the case, then all we will need is a name change for the establishment, and that won't be as much an issue as if the LLC was being dissolved and there was new ownership coming in, taking over the
I have stock in Rose Mortuary, but if we sell Rose Mortuary, it's still, we're selling Rose Mortuary.
Right.
I won't have my stock anymore, but the corporation is still there as an entity. So that's the way I'm looking at it. In other words, Mr. Smith's getting out,
Right.
but he still bought the corporation, so it would just look like it'd be a name change to me.
You exactly
That's the way I would interpret it.
Mr. President, how about this? How about if it turns out to be a name change to where he just wants to change it to SAG Funeral Services, then I can administratively approve that with this board's permission. And then if it turns out to be an ownership change, I think probably our legal counsel needs to speak with his legal counsel and get the documents to see exactly, I understand exactly what Mr. Starkey's saying, but then based on what's been said earlier, I'm still somewhat confused. But I guess, and again, I accept responsibility for you not being officially on the agenda, and I apologize to you for that. That's just an oversight on my part. But I guess what I'm asking the board is, through a consensus of the board, is it okay to do either one of those, whichever he needs to do? He's paid the money to do a name change. If that's all he needs, that we can approve it. If he wants to use SAG, once he submits an amended application, and then if it turns out after Mr. McDonough speaks with his general counsel, legal counsel, that he needs to do a change of ownership forms, he'll file those forms, and then we'll approve the name as SAG Funeral Services.
I make a motion, we accept Robert Grewell's recommendation.
I second.
Motion has been made by Mr. Starkey, seconded by Ms. Taylor, for the executive director and legal counsel to move forward with the name change approval of SAG or SAG Funeral Home if everything works out through the two, Mr. Ganaway's counsel and board counsel. If all of that works itself out, that's agreeable to both parties, then we have a motion on the floor and a second that be approved. I will make an additional comment. I'm only agreeable to that to the extent that our office admits a problem with the agenda for today, maybe an oversight on our part, because I certainly don't want to set a precedent of hearing these matters like this when all the details aren't in place to start with. So with that said, any further discussion? I don't want this to be a precedent for the future, but since there is apparently some error on our part, I'm willing to move forward if that's the will of the board. We have a motion and a second. Any other discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Anything else from legal counsel, executive director, or board members? Hearing none, the chair will entertain a motion for adjournment.
Make a motion.
Mr. Neal, second Mr. Hinkle. All in favor say aye.
Aye.
Thank you. Motion adjourned. Meeting adjourned, excuse me.
Motion to doctor's appointment tomorrow, but I'm telling you.